Alright, let's look at Standard 25 Substandard B. Explain the impact of Supreme Court decisions on ideas about civil liberties and civil rights. Okay, there's the comma, including. So we get from this first part up here, at close reading, we see that civil liberties and civil rights are two things that our standards want us to know about. In other words, the EOCT is going to test us on our knowledge of civil liberties and civil rights. So we need to know what these two things mean. What are civil liberties? What are civil rights? Now, in what emphasis are we going to be looking at these? It says comma. Then it says including. There's that magic word. Such decisions as Roe v. Wade 1973 and the Bakke decision, which was 1978, on affirmative action. And the Bakke decision on affirmative action. So we have two cases, Roe versus Wade and Bakke. Regents of University of California versus Bakke in 1978. Those two cases are going to give us examples of the court's ideas, Supreme Court's ideas on civil liberties and civil rights. So we're going to look at that in this Standard 25 Substandard B. So our focus here is on civil liberties with the Roe versus Wade case, and civil rights with the Bakke or Regents of University of California versus Bakke. And that is not the themes of this case. Civil liberties, civil rights are the themes of this particular standard and substandard. And so our focus is going to be on civil liberties, or we've talked about these before, individual rights, and it's going to be on civil rights or individual rights to equality. Right? So we've talked about these before, and before we talked about where do civil liberties and civil rights get their source from? What are they? Civil liberties are connected with the Bill of Rights, the first 10 amendments. We have civil liberties elsewhere in the Constitution, okay, don't get me wrong. But to simplify this explanation, let's just say it comes from the Bill of Rights, civil liberties, especially in the cases that we're looking at. The 14th Amendment Equality Clause, Equal Protection of the Law Clause, is the source of civil rights in this particular case. Okay, so the civil rights we're talking about comes from the 14th Amendment Equality Clause. Issues dealing with equality are usually civil rights. The Bill of Rights, when we talk about the amendments, are civil liberties, protections against our government, individual protections against our government. All right. So let's start with civil liberties first. The Supreme Court's ideas on civil liberties. So let's focus on civil liberties first. Okay, we talked about civil liberties first when we talked about Ernesto Miranda in the Miranda versus Arizona in the 1960s, and the Miranda warnings or Miranda rights that had to be read to you, that you have a right to a lawyer, you have rights against self-incrimination. The court said that Ernesto Miranda had rights to civil liberties to be informed of these rights. Okay, so we talked about these civil liberties before. They come from the 5th and 6th Amendment. He was questioned by police under interrogation. We looked at that last time, and he made a confession and then later withdrew his confession, saying he didn't know, he didn't have to talk to them, that he didn't have to talk about himself and self-incriminate himself, and that he had a right to a lawyer. And the court said that police all across the United States had to inform before interrogation, had to inform suspects of crimes of their right to a lawyer, rights against self-incrimination. That is what we call the Miranda rights or Miranda warnings. Those are civil liberties. Okay. We also talked about Clarence Earl Gideon here. Gideon versus Wainwright was a case prior to Ernesto Miranda's case, Miranda versus Arizona, in which he asked for a lawyer because he was poor and couldn't afford one, and said his 5th Amendment right to a lawyer had been violated, or 6th Amendment right to a lawyer, had been violated because he was refused a lawyer while he was going to trial. Okay, so we see that both of these cases stem from the 6th Amendment, right to a lawyer, and the 5th Amendment, rights against self-incrimination. And so these are civil liberties that we were talking about before. And we also talked about, we talked about socialist Eugene Debs, how he spoke out against the war, World War I, and he was a labor. He was speaking for labor. He spoke out against World War I, and we talked about that in detail in a past video, but the Espionage Acts, a lot of people felt violated the First Amendment right to free speech, which is in the First Amendment to the United States Constitution. And in the First Amendment it says, Congress shall make no law respecting the establishment of religion, prohibiting the free exercise thereof, or abridging the freedom of speech. Right there. So a lot of people felt that Eugene Debs' civil liberties had been violated. But it was during time of war, and he was locked up for 2 or 3 years, but then his sentence was commuted by the president. But those are civil liberties, First Amendment rights to free speech. And the definition we talked about civil liberties were protections for individuals or groups against the government and its actions. Individual protections are usually located within the Bill of Rights, and we gave some examples of those before: right to a lawyer, rights against self-incrimination. These are usually a lot of them 4, 5, 6, and 8 are for people accused of crimes. You know, we talked about this before, and we used a few of these examples. But then let's turn to Roe versus Wade. See, how is Roe versus Wade an example of civil liberties? You know, that's what we need to look at. In Roe versus Wade in 1963, a Supreme Court case, a case was filed all the way to the Supreme Court, and it's called Roe versus Wade because Roe was given to a woman who wanted an abortion at the time in the state of Texas, and she challenged the Texas law banning abortions within that state and said that it was unconstitutional. It violated her Fourth Amendment right to privacy of her own body and to make a decision to get an abortion. They called her Jane Roe in the newspapers and in the media and all. Later on, she comes out. Her name is Norma McCorvey. She says, "I'm Jane Roe. I'm the woman in this case." But during the case in 1973, she's just referred to as Jane Roe because she didn't want her identity being given to the public. And the Attorney General of Texas was Henry Wade, okay, arguing that the law in Texas banning abortion, making abortion unlawful, was perfectly constitutional and legal for the state to do that. And so here's a woman saying, no, it's unconstitutional. Here's a guy in the court saying, no, it's constitutional for Texas to do this. That's what the case was about. So the court had to make a decision. Can a woman, is the Texas law or state laws keeping a woman from getting an abortion, are they unconstitutional? And prior to this case, there were 30 states in red. Texas is one of them that just said abortion is illegal. There is no reason why a woman should get an abortion. Okay. Notice that Georgia is green. In Georgia at the time, if a woman's life was in danger, if her health was in danger, she was raped, there was an act of incest, or there would be a likely damaged fetus, the baby would be born with severe disabilities, then in those some instances women could get an abortion. And then we see that Alabama here, if the woman's health is in danger, she could get one there, but that was the only reason. And in cases of rape in Mississippi, that was the only reason the woman can get an abortion. And then on request, we see that in New York, state of New York, and in Washington state, a woman, and in Alaska and Hawaii, a woman can get an abortion on request anytime she wanted to. So across the states, abortion was dealt with differently. So the issue here before the court is, do women have reproductive rights, a Fourth Amendment right to reproduction, because they have a privacy in their body? Okay, so this case comes out of Texas. Norma McCorvey is from Texas, and so her and her lawyer fight this case. She's known as Jane Roe. Here's her attorney here, and this sets off this dispute across America. And they wore off into camps: pro-life and pro-choice. Pro-life means people that say women should not be allowed to get an abortion. It should be entirely illegal. Okay, and you're going to get some differences of opinions, or what are some exigent circumstances would allow a woman to get an abortion. You're going to have a lot of differences of opinions here in pro-life. But pro-choice means a woman should be able to get an abortion anytime she wants to, on demand, anytime at all. Okay, So we see that the United States becomes very split on this. Here's some women here asking for safe legal abortions for all women. The National Organization of Women, Betty Friedan, introduced, that we talked about earlier as a social reform movement, demands women have the right to an abortion. And then on the other camp are parents and the moral and religious groups that says you should not kill babies. Killing babies, I mean, abortion is actually murder. We shouldn't allow women to do this. Okay. So, in the case Roe versus Wade, 1973, the Supreme Court ruled that a woman had a Fourth Amendment privacy right to her body within the first trimester. Right here. Within the first trimester, within the first 3 months of pregnancy, a woman had a right to get an abortion if she wanted to. Okay? So, the court said that all laws in the states that forbid an abortion within the first trimester are unconstitutional. So, in this case, the Supreme Court of the United States gives reproductive rights to women within the first trimester, within the first 3 months of pregnancy. Okay, so the court ruled this way. The majority opinion of the court was that 7 justices granted reproductive rights to women. And even on the court, it's controversial. And here's the majority opinion: 1, 2, 3, 4, 5, 6, 7. Justice Blackmun writes the majority of the court, and they grant reproductive rights. There it is. Reproductive rights to women. Let's bold that. And that's the majority opinion of the court within the first trimester. There are 2 dissenting votes. Judge Byron R. Wyatt and William H. Rehnquist. They oppose the majority's views. Okay. And so the majority here argue that a woman has a Fourth Amendment right to privacy of her body because the Constitution is the right of the people to be secure in their persons. Against unreasonable searches and seizures shall not be violated. And that's what they get this right to privacy from, that is implied that a woman has a right to privacy. And here's Justice Blackmun in his majority opinion, January 22nd, 1973, Roe versus Wade. He says, the right of privacy is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. The detriment that the state would impose upon the pregnant woman by denying this choice altogether is apparent. Okay, so he says that the Fourth Amendment right to privacy gives a woman a right to terminate her pregnancy in the first trimester, pretty much. All right, and Justice White is one of those dissenting votes. He's this guy right here. He writes the dissenting opinion. William H. Rehnquist is going to join him in that, but it is White that's writing dissenting opinion. And Justice White wrote this: with all due respect, I dissent. He's saying, I disagree. I find nothing in the language or history of the Constitution to support the court's judgment. The court simply fashions and announces a new constitutional right to pregnant mothers, and, with scarcely any reason or authority for its actions, invests that right with sufficient substance to override most existing state abortion statutes. In other words, all states now had to abide by reproductive rights of women. Okay. And then he further says, the court apparently values the convenience of the pregnant mother more than the continued existence and the development of the life of potential life that she carries. I cannot accept the court's exercise of its clear power of choice by interposing a constitutional barrier to state efforts to protect human life, and by investing mothers and doctors with the constitutionally protected right to exterminate it. Okay, so he disagrees with the court's decision. But in the court's decision, the majority opinion was that a woman had a right to privacy of her body and therefore had reproductive rights, could determine if she could have an abortion or not, or abort her fetus, or terminate her pregnancy within the first trimester. So the court says civil liberties for Norma McCorvey or any woman who wanted an abortion within the first trimester, the government cannot restrict that because she has a right, Fourth Amendment right to privacy and reproductive rights of her body. Okay. Now, that does, I mean, the case is still very much controversial. A lot of pro-life people are trying to get the court to overturn Roe versus Wade, excuse me, and pro-life advocates are still pushing and trying to put pressure on the government to do that. And here's Norma McCorvey here, Jane Roe, with her attorney later on, fighting to keep abortion legal. And notice here at the bottom of the sign, now National Organization of Women are pushing to keep abortion legal. Here's another group here. You see the now sign, keep abortion legal. And Roe starts out as a, fighting for her rights. But later on, she changes her mind. And she says abortion hurts women. She becomes a pro-life advocate, saying that she made a mistake. She was 22 years old. She didn't know what she was doing. She was scared. At any rate, here lately, there's a lot of people say she went back to advocating pro-choice. So she's really not consistent in her goals. She's got a lot of pressure coming from both sides. So there she is opposing, trying to keep abortion legal. Here she is trying to reverse her own decision, Roe versus Wade. Alright, so with that, I want you to understand that, with Roe versus Wade, it is an example of civil liberties in our standards. And so keep that in mind. Connect Roe versus Wade 1973 to right to privacy and the Fourth Amendment, reproductive rights, and civil liberties. Alright. And that's where we see this in our standards. Explain the Supreme Court's ideas about civil liberties. Roe versus Wade is the example. Alright. Now, there's a second part to that. We have to talk about civil rights. So let's turn to civil rights. And that's our focus here. And the example of the Supreme Court's ideas on civil rights is the Bakke decision. Alan Bakke, we're going to talk about here in just a second. So we see that, civil liberties like Roe versus Wade, the Fourth Amendment is a civil liberty under the Bill of Rights. But down here, civil rights are based on equality issues with the 14th Amendment. And so civil rights as a definition are rights to personal liberty established by the 14th Amendment of the U.S. Constitution, and certain congressional acts, especially as applied to an individual or minority group. An example of civil rights, Homer Plessy and Plessy versus Ferguson, we talked about how Jim Crow and segregation really violated his rights to equality. He was denied equal protection or equal treatment under the law, and he was separated into different things. Now the Supreme Court at the time said it was separate was equal, but after that in 1954 we see the court reversing the trend, saying that his civil rights had been violated. Okay, so those as an example. Characteristics: equal rights, all citizens treated equal are the same under the law. Non-examples of civil rights are Jim Crow laws, segregation, and discrimination. Alright, and we use this as an example. And so let's turn our attention to the Bakke case as an example of civil rights. Alright, first of all, we have to talk about this term. It's kind of complicated at first, but it makes sense as we go. Affirmative action is a policy by the government or by education facilities like the University of California at Davis, the School of Medicine there, or other universities or other places that hire. There are policies that take factors including race, color, religion, sex, and national origin into consideration in order to benefit an underrepresented group. In other words, University of California Davis School of Medicine, if it wanted to accept a number of minority candidates into its school, that would be just because they were black, or just because they're Hispanic, or just because they're female, then that would be affirmative action. They would be accepting them on the basis of their minority status. And it's also in areas of employment and business, but in this case we're talking about here in the Bakke cases in education, based on race and in education. That's affirmative actions, giving preference to a person because of their race in their admission to the University of California at Davis's Institution of Education, School of Medicine, to become a doctor. In other words, you as an applicant are accepted because you're black or because you're female. Okay. So our issue here is in California, in Davis, California, near San Francisco. University of California, that its campus located at Davis, was a medical school. And this gentleman here, Alan Bakke, it filed for admission to the University of California, Davis. He wanted to go to medical school there. He wanted to be a doctor. And he was denied because he was a white man and because of a quota system used by the university to admit African American students or minority students to fill certain quotas for minorities. And so let's look at this a little bit closer. Let's see how was Alan Bakke, how is he saying that his equality, his civil rights were violated? The medical school at University of California, Davis had 100 seats open and was accepting admissions for those seats. So these desks were going to be filled by 100 people to become doctors. All right. What University of California, Davis did was establish 16 seats out of the 100. That would be 16% of that year's enrollment or admissions would be from ethnic minority groups. African American, Hispanic, Asian, and Native American. Okay, so they established a quota of 16%. 16 seats out of the 100 would be given to ethnic minorities. All right. So what they did was they set up a separate admissions process for these 16 seats. In other words, they would do a process for the other seats and then go through that, and then for these 16 seats had to be ethnic minorities, had to be these groups here, or ethnic minorities they wanted to accept. Now what happened was Alan Bakke applied for admission under the 16-seat minority admission process. So of course he was denied admission to the university because he went in under this admission process for the minorities. All right. And so Alan Bakke sued the Regents of the University of California and the medical school there at Davis. He argued that his 14th Amendment right to equality was violated. In other words, his civil rights were violated. All right. So this is going to go to court, but the University of California, or the Regents University of California, are going to say we do this separate admission process for these 16 seats. Okay, we do this process here for these 4 reasons. 1, reduce the historic deficit of traditionally disfavored minorities in medical schools and the medical profession. In other words, we want more minorities to be able to get their medical profession degrees and practice as a doctor. To counter the effects of societal discrimination, they do it to counter racial discrimination. And 3, to increase the number of physicians who were practicing in communities currently underserved. In other words, they wanted there to be black doctors in these communities that need black doctors. And then obtain the educational benefits that flow from an ethnically diverse student body. They want a student body that is composed of diversity, of a group of different races and groups. All right, so that's what they argue. So before the Supreme Court, Alan Bakke actually went to the California highest court and actually won. You know, the California court said it was reverse discrimination. He needed to be accepted by the University of California at Davis Medical School, that it was unconstitutional for them to have a quota system. So it goes all the way to the Supreme Court. The University of California, the Regents system, takes this to the Supreme Court, and the Supreme Court actually votes on a rule of 4. 4 of the 9 agree to review it. And so in 1978 they had 2 questions before the Supreme Court. The quota system used, the quota system of the 16 seats, okay, that's a quota, 16%, separate admission process. Did it violate the 14th Amendment Equality Clause? Did the University of California Davis violate the 14th Amendment with this quota system? That's the first question they had. The second question they asked, what about the policy of affirmative action? Preferential choosing of minority groups for business or jobs or for education in schools. Does that policy violate the 14th Amendment? these two questions are going to go before the Supreme Court of the United States. And while it was going, a lot of groups went out protesting, saying we need to defend affirmative action, keep that policy in place because we need African Americans in schools. And here's a group of African Americans says fight for integration and equality for African Americans. It's part of the civil rights movement. And then this one says defeat Bakke and affirmative action and extend affirmative action. Yeah. Overturn the Bakke decision. There's people protesting it after the decision. And here's one here. If Bakke wins, this one's before, we all lose in employment, education, and housing. And on the other side of this controversy were whites or other groups who contended that, you know, affirmative action is really reverse discrimination against whites and other groups. And here's a kid holding up one here. It says, I'm a victim of a hate crime, affirmative action. It's a white kid. And this kid here has the content of character, not the color of skin. In other words, he's using a quote from Martin Luther King Jr.'s I Have a Dream speech. And they're fighting, saying that affirmative action is reverse discrimination. So this affirmative action and is under attack here. So let's look at this question of the quota system used by University of California at Davis. The court had asked, was it constitutional to use this? 5 of the justices out of the 9, 1, 2, 3, 4, 5. 5 justices vote for the majority, and they said yes, that the University of California at Davis, their refusal to admit Alan Bakke on the quota system, on the 16% or 16 seats out of a 100, that system is unconstitutional. It violates the Civil Rights Act of 1964 and the 14th Amendment. Okay? And so they ordered that the University of California at Davis Medical School admit Alan Bakke. And they said that his quality rights have been violated. 4 of the justices voted against the Bakke decision, voted against Bakke and said the quota system was perfectly okay, and they dissented from this. So it was a split decision, 5-4. Okay, that was on the quota system. The other question was, is affirmative action unconstitutional? Now Justice Powell here splits, he jumps back on the other side of the fence. Notice that Justice Powell is here with the quota system saying that the quota system is unconstitutional. However, when it comes to affirmative action, he says affirmative action is perfectly constitutional. And so these men here, the 4 who were in opposition to the quota system being unconstitutional, dissenting votes, are joined by Powell here, and he says he held that the use of race as a criterion in admissions decision in higher education was constitutionally permissible. Powell joined the opinion as well as these 4 men, and on affirmative action the court upholds the use of affirmative action in the education process. However, the quota system, they said the way that the University of California Davis went about it was unconstitutional. Can't just pull out 16 seats and have a separate admissions process for those ethnic minorities. That's unconstitutional and causes a case of inequality or a violation of the 14th Amendment. So on the original questions, the Supreme Court had to answer in 1978 with this case, is a quota system used by University of California Davis, is it unconstitutional? They said yes, it is unconstitutional. It is reverse discrimination. So don't use a quota system anymore. But on affirmative action, they said that the policy of affirmative action is okay. It's legal, it's perfectly constitutional, and it is not reverse discrimination. Okay? And so the Supreme Court of the United States in the Bakke case said that Alan Bakke's 14th Amendment civil rights had been violated. He was denied equal treatment and equal protection under the quota system that was used by the University of California Davis Medical School. So that's an example, the Bakke case, an example of civil rights. So Bakke does graduate as a doctor and is still practicing today, from what I understand, up around the Great Lakes state, somewhere up there. What does Bakke mean? Quotas? No, can't use them. Race? Yes, we can. We can use affirmative action, but we can't use quotas. Alright, so I think that brings us to an end. Explain the impact of the Supreme Court decisions on ideas about civil liberties and civil rights, including the decisions Roe versus Wade, which is civil liberties, and the Bakke decision, which is civil rights, on affirmative action. Alright, if you have any questions, ask them in class. Good luck on the quiz test EOCT.